Mic check 1, 2. All right. Hello, hello. This is going to be Just Human episode 370. And I just want to drink coffee and get into some court cases with you. So if you're in the mood for that, I'm going to talk about the United States versus Southern Poverty Law Center case. There's been some filings in that, some documents I want to go through. And then there's been some controversy in the Cole Tomas Allen case, the would-be Trump assassin from California who went to the White House Correspondents Association dinner and blasted through a security checkpoint with a shotgun, failed to eject a shell, and maybe tripped down some stairs, or was tackled, or was tripped by Secret Service. Not sure which, hasn't been explained yet. But there's been some controversy with him, how he was treated in the jail recently, and then comments made by the judge. And I think in that segment, you're going to see that I'm able to neutralize a lot of that outrage by simply going by some documents and some context and trying to appreciate what the situation actually is. So, understanding is greater than reacting. That's that's what that segment is really about. And I update you on what's going on in that case. So, those are the two cases I have in front of me, and I think that's about all I'm going to get through in this episode. We'll see if I have time for some other things. So, if that sounds interesting to you, welcome. On my link tree, you can find all the places to follow me, all the places to watch, all the places to listen, and all the different ways to support. Thank you to everybody who supports what I do through all of these links here, whether it's purchasing at Benson Honey Farms a bootleg, Manly Cans, or it's buying me coffee at ko-fi.com. And especially thank you to everybody who's a paid subscriber at justhuman.substack.com. That is the best way to fund my access to these documents and to keep me caffeinated. $7 a month keeps me caffeinated, keeps these documents coming. And that's what we're going to get to right now. Also on Rumble and YouTube, I'm continuing to upload my podcast over there, just like I do Substack. But on Rumble and YouTube, I also upload clips and shorter form videos, and I put those on playlists by topic. So there's basically a playlist for each case that I cover. And by the way, I haven't done an update in a while on the defense contractor who stole the information for WaPo and the classified info about Venezuela. I haven't done an update on that in a while. We may hop over there and just check that docket. The last time I checked it, I really didn't see anything that would make for a great video segment. And I also haven't updated you on the Don Lemon case. Everybody in that case, everybody who invaded that church has now been indicted. That's great. And then everybody's making their separate filings and motion to dismiss and stuff. And so it's a lot to go through. I'm sure everybody's interested in what's going on with Lemon. He really is he makes a big difference there. He's the unique person, him and his media people that were with him, like his producer and one other cameraman. They are unique figures in that whole organization. So I expect they're going to be treated a bit differently because they are different, because the judge has to decide whether or not they qualify as media there who were exercising their First Amendment rights to do journalism, right? Which I think they crossed the line. You probably think they crossed the line. Hopefully, Harmeet Dillon and the DOJ can convince the judge that Lemon and his producers crossed the line and how they behaved and what they did on that day. So I'll try to remember to jump to that and give you an update on what's going on with these two cases. But first, I want to talk about the Southern Poverty Law Center. All right. Hope you got your coffee. So in the previous episode, I went through just the indictment. Since the indictment has come out, as you might have guessed, there's been a ton of attorneys filing their appearances on behalf of the Southern Poverty Law Center. The SPLC is not going to have a difficult time getting attorneys to work for them. They're one of the institutions on the left, and they have connections all over the place. So right now they're represented. They got Abby Lowell, who of course pops up in any controversial Democrat case, represented Hunter Biden, represented someone else. recently that was a big controversy. Now I can't think of it. Oh, Bolton. He's representing John Bolton. And then you got the Crop mostly Schmidt, which is like the all-female law firm, I believe, and some others that are there. I bet there's going to be more. There's probably going to be some filings by interested parties praising the SPLC and talking about how bad DOJ is under Trump, just like we saw with Comey. This is going to be one of those cases where there's just a lot of attorneys and special interest groups filing on behalf of the SPLC. Okay. Criminal defense attorney. Let's retain criminal. Okay. I don't need that. Does it say which one is the lead attorney? Like, who is the attorney to be noticed? Lead attorney to, they all say it. They all say attorney to be noticed. They all say lead attorney. Every single one says attorney to be noticed, lead attorney. I wonder who's going to be the actual lead. I bet it's going to be the all-female crew. But maybe Abby Lowell. Okay. Arraignment May 5th, today, 10 a.m. So that has happened. That already happened. And Sarah Kropf is probably going to be Andrea Mosley, Addie Schmidt. Those are going to be some of the stars of this case, I would guess. All right, April 28th, one of the first things they did was they filed a motion to disclose the grand jury proceedings, followed by motion to address the government's materially false statements, and then the government has until today to respond to the disclosure of grand jury transcripts. They haven't filed it yet, but maybe before I get done with this recording, it'll be filed and I can go over that too. The government also has until today to file a response for that next filing addressing their materially false statements. And that also says asking the court for an order to enforce rules prohibiting further prejudicial and extrajudicial statements by the SPLC. Motion for protection. So this right here gets to something I've commented on a number of times. I think that DOJ, I think Trump, I think some of his attorneys, I think Blanche, I think Kash Patel, I think they say too much. I think one of the reasons that Pam Bondi caught a lot more flack than she deserved is because she said too much to the media. And that's just the nature of this administration. Trump has hired a lot of people who love the camera and love the microphone and just can't help themselves and are constantly trying to attack the media and call them fake news and whatnot. Not saying the media doesn't deserve it, that I don't, empathize or emphatically agree even with a lot of the things Kash and Blanche and Bondi and others and Trump have said to the media, but I don't think it wins them much. I think they need to be more choosy in their battles. And one of the things that gets them in trouble is commenting on ongoing criminal matters. It's unprofessional and it causes trouble because you can prejudice juries, and these defendants and their attorneys are looking out for, they know, and the media knows, that they can goad people in the Trump admin into saying things that aren't helpful to the prosecutors and the trial attorneys. So say less. Let the documents do the speaking. That's my advice. So, okay. Let's get to this first one. Southern Poverty Law Center's motion to disclose transcript of grand jury proceedings. So, in United States versus SPLC, where they filed charges for conspiracy and, the SPLC, alleging that the SPLC was paying all of these informants inside the extremist groups to do extreme things, and then was fundraising off of that. So they were sending hundreds of thousands of dollars to the very extremist groups that they were then fundraising off of and saying we were going to work to dismantle these groups. They were also paying for these groups to do extreme things. And so there's a circular relationship there, and it's fraudulent. And and then in addition to that, the conspiracy to fraudulently raise money off of this arrangement with informants and not disclosing that arrangement to their donors. They also created fictitious entities at banks, at least two banks, and they signed documents saying that these were businesses that were paying these informants for work for the business, when really it was just a means of uh, covering up, of clandestinely transmitting money to these informants to go and engage in extreme things with these extremist groups. And so there's bank fraud, wire fraud in this case. And since the indictment of the SPLC has, like I said, taken on a lot of attorneys, and they have now their first motion of substance, their first key filing is a motion for disclosure of grand jury transcripts, of the transcript of grand jury proceedings. They want to get at the materials that led to the indictment coming about. And one of the reasons that you find through this document that they want that information is because the SPLC has already been investigated just a couple years ago. And they worked with the Justice Department in that investigation, according to them. And they explained what they were doing to the Justice Department. And the Justice Department either decided not to bring charges, closed the investigation, tabled it, something. And then all of a sudden, now that Trump's in charge, the indictment has come. And so the SPLC is wanting to look at the grand jury and see if there was anything irregular about the grand jury proceedings that led to them being indicted, and if things had been mischaracterized to them or misrepresented to the grand jury that led to this indictment. They introduced themselves in this, saying, for over half a century, we've served as a cornerstone of American civil rights litigation. And while you and I may disagree with that, and maybe some others disagree with that, that is very much how they see themselves, and that is how the left sees them. Remember, this is an institution, like on the level of Planned Parenthood, of other hardcore leftist orgs who people on the left believe are just and super important and praiseworthy, and will basically look the other way and or praise whatever this group does because it's in the name of the cause. Just like that's the Marxism and the Maoism coming out in the left. Those who are the most leftist and Maoist and Marxist. Remember the issue is never the issue. The issue is always the revolution. And so the SPLC has a blank check to do whatever they want. And it's a fortunate thing that they're headquartered in Montgomery, Alabama, and that's the district that such a litigation like this could be brought, because something like this being brought in a leftist city, pulling from a leftist jury pool, I would bet on them getting away with it, because the left sees the ends justify the means. I'm riffing a bit. I should read the document. All right. This indictment represents a stunning and unremitting departure from Justice Department policy and established law. It seeks to criminalize some of the very investigative tools and programs that the SPLC has used for decades to infiltrate and dismantle violent extremist organizations like the Ku Klux Klan, and Aryan Nations, tradecraft that has produced vital intelligence that has been shared with law enforcement, including the FBI. This prosecution is unprecedented as it is irregular. Comments made by the administration officials and flaws in the indictment itself suggest the case results from misleading both the public and the grand jury that voted on the charges. Moreover, on its face, the indictment suffers from obvious legal infirmities, including the omission of essential elements of intent and a failure to reconcile the charges with recent Supreme Court precedent. And the footnote there is these and other deficiencies in the 11-count indictment will be the subject of a forthcoming motion to dismiss. These particularized irregularities, and that language is what you need in order to get access to grand jury materials, they have to show that they have a particularized concern or need to look at the grand jury materials, and they have information as to irregularities in the grand jury process or grand jury materials. These particularized irregularities, so they're using, I'm just telling you that because they're using those words on purpose. That is the legal standard they have to get at and show the judge in order to get it granted, this access granted to grand jury materials, which is normally protected, and for very good reason. These particularized irregularities suggest that the grand jury was not merely misled by the government's presentation of the law, but likely that it was actively weaponized to facilitate such charges. In light of these irregularities already uncovered and the manifest risk of prosecutorial misconduct, the SPLC moves this court under Federal Rule of Criminal Procedure 6E3E2 for an order compelling the disclosure to the defense of the full transcript of the grand jury proceedings in this case. And if that sounds familiar to any of you guys, it's because we went through this same thing in United States v. Comey last fall, and we talked a lot about access to grand jury proceedings. And of course, the grand jury process in United States v. Comey last fall was irregular. And there were a lot of problems. If I remember right, there were either 10 or 11 findings by a judge as to irregularities and problems with the grand jury proceeding in that case. And then ultimately it was dismissed. The veil of secrecy that usually shrouds grand jury proceedings and the presumption of irregularity historically afforded to such vital proceedings cannot be used as a shield for a prosecution that is so clearly untethered from the facts, the law, and the historic relationship between this organization and the very law enforcement agencies now seeking its destruction. I would, I should make it a point. The next time we want to tell someone that they're lying, instead of saying you're a liar, we should say, you, sir, are clearly untethered from facts. I like that. All right. On April 21st, 2026, a grand jury returned an indictment charging the SPLC with wire fraud, making false statements to a federally insured banking institution, and conspiracy to commit money laundering. Since that moment, statements of officials at the highest level of the admin have called into question the information given to the grand jury and, in turn, the indictment itself. The indictment repeatedly alleges the SPLC sought to promote the Unite the Right rally in Charlottesville, Virginia in August 2017. Indictment, blah, blah, blah. And F-37 was a member of online leadership chat group. You may recall. F-37 made racist postings. All right. Additionally, Acting Attorney General Blanche said publicly that the government had no information that suggests that the SPLC then turned around and shared what they learned with law enforcement from the informant program. Neither the allegation in the indictment nor Blanche's statement is true, and the government knows or should have known that. Let's see, they have okay, this is a link to Blanche's comments, which I accidentally clicked on. Pro move. There's a pro move there. Let me go back and find my place. The SPLC used the informant program to gather voluminous and detailed information about the risk of violence at Charlottesville. That information was memorialized and provided to law enforcement, including to the FBI's Mobile, Alabama office, the very office leading the investigation of this case, in advance of the rally in the form of a 45-page event alert. That document warned the FBI of the specific individuals likely to attend the rally and foment violence, providing not only names and pictures, but specific details about associates' backgrounds and criminal histories. Let's see the footnote. A copy of the above referenced event alert has been provided to the government. If requested, defense counsel can furnish a copy to the court through a supplementary under seal filing. It would be interesting if we got to see that filing with some redactions for privacy, but it would be great if we got to see that event alert, because we might be able to discern exactly who this person is and whether or not it's Nick Fuentes or some other person that's identifiable from the leadership of the Unite the Right rally. And it would be interesting what information they did provide the FBI about the Unite the Right rally and what information they did not. For some of the individuals identified in this event alert, the SPLC even provided details about those individuals' weapons of choice based on intelligence gathered through the informant program. In addition to the false claims about Charlottesville, administration officials have made repeated false and highly prejudicial statements about the SPLC and its activities, including the fanciful and baseless claim that the SPLC is giving money to the KKK, an allegation not even supported by or contained in the indictment itself. In announcing the charges, Acting Attorney General Blanche asserted that the SPLC, quote, paid sources to stoke racial hatred and, quote, manufactured racism to justify its existence. During an appearance on Fox News following the charges, Director Patel escalated the rhetoric, claiming that the SPLC, quote, turned around and paid the leaders of these very extremist groups and used donor funds to sow discord and hate. And in a naked display of politicization and partisanship, President Trump posted, quote, Southern law, whatever it is, has given money to KKK. They're supposed to protect people and they're paying all these people, crooked as can be, millions of dollars going all to all these people that they're supposed to be protecting from. The president reiterated in another post, quote, the Southern Poverty Law Center, one of the greatest political scams in American history, has been charged with fraud, and calling the SPLC a Democrat hoax and attempting to link the fraud charges to his broader debunked claim of election interference. These repeated false and prejudicial remarks by the admin, most senior officials, not only violate Justice Department norms and long-held principles of federal prosecution, but they illustrate, among other things, the stunning and blatant irregularity, politicization, and manifest risk of prosecutorial misconduct in this case. And if you find yourself rolling your eyes at any of this, or shaking your head, or thinking that the SPLC is whining too much, I have to tell you, I recall people being very upset about things that Joe Biden and Merrick Garland said and Christopher Wray said about the prosecution of Trump and others. So, I mean, it's just what's good for the goose is good for the gander. What's bad for the goose is bad for the gander. Cuts both ways. All right. The argument section is all about how the grand jury is sacred, which it is. And it's stuff I've gone over many times before if you were with me for the Comey stuff. And it's really simple. Grand jury stuff is, as a rule, secret. And it's secret in order to protect the witnesses who testify, in order to protect the members of the grand jury. And there are only certain exceptions that would allow for a judge to disclose anything that happened in front of a grand jury to the defendants or to the court. And there has to be a particularized need for it to happen. This is the 11th Circuit where this thing is happening. That's the standard there. They have to show a particularized need to look at the grand jury stuff, and it has to outweigh the interest in maintaining secrecy. That's how the scales have to balance here. So that's what they have to show. And we'll see if they do that. We'll see if the judge agrees with it. The judge might, like in the Comey case, the judge might defer this particular thing to a different judge. And that judge's job will just be to look at this issue only and decide whether or not that standard has been met. If the government, if before the grand jury there are some witnesses who the government can argue, we need to keep their testimony secret, we need to keep their identity secret because they testified and it would put them at risk to blowback, that's going to be a big concern because we're dealing with extremist groups, violent extremist groups. And witness intimidation is going to be very much a consideration in whether or not these grand jury materials are going to be disclosed. So I think depending on what happened in front of the grand jury, things are already going to weigh in favor of secrecy, but they might weigh even more so, it would seem to me, in favor of keeping the grand jury material secret because of the type of groups that are connected to this. All right, Rule 6E permits disclosure when needed to avoid a possible injustice in another judicial proceeding. It has to guard against fishing expeditions. Y'all can let me know if you really want me to go through all of this kind of stuff, but we went through it so much in the Comey thing, which, oh, look, it mentions the Comey case. Yep. And we just spent so much time on it that I don't really feel the need to go through it. I want to get to the court should not ignore the broader political context in which this extraordinary prosecution was brought. Public reporting has indicated that the investigation into the SPLC was, quote, shut down during the Biden administration, only to be revived during President Donald Trump's second term. And last year, Director Kash Patel criticized the organization as a partisan smear machine after Charlie Kirk's assassination. As described above, the president, the acting attorney general, and the FBI director are engaging in blatant politicization and public shaming of the SPLC. The glaring flaws on the face of the 11-count indictment and Director Patel's decision in October 2025 to sever information sharing ties between the FBI and SPLC all paint a picture of striking irregularity here, which you guys are probably aware. The SPLC for years sent reports to the FBI, which the FBI, depending on who was running it, would use those reports to inform agents, to inform investigations. These irregularities include the Justice Department's failure to subpoena or even contact the SPLC during the investigation. Instead, and they cite a declaration right here. We're going to get to that in a second. Instead, the SPLC contacted the U.S. Attorney's Office in an effort to understand the nature of the government's concern and obtained a meeting on February 25th, 2026. At that meeting, which was attended by acting U.S. Attorney Kevin Davidson and two assistant U.S. attorneys, the prosecutors advised that they had been advised the records of the informant program had been destroyed. The SPLC corrected this erroneous belief and agreed to accept service of a grand jury subpoena for records which included the information gathered through the informant program, some of which was provided to law enforcement. Some. The SPLC produced approximately 15,000 pages of records in response to that subpoena on April 17, 2026. 2 business days later, on April 21st, the grand jury returned this indictment, which contains no reference to the information gathered by the informant program. Okay. Did they trick the SPLC into giving them that information? Just going to toss this thought out there. Had prosecutors sought that information before in the previous investigation and the SPLC had told them it was destroyed? And then at this meeting, they're like, well, it's our understanding that the informant program information y'all had destroyed, y'all didn't have any records of it. Those were missing or destroyed. And in an effort to combat this new investigation, did the SPLC say, no, we have those records. We'll give them to you. And then they turn them over and immediately after they get indicted. Was that a very clever gambit by prosecutors? And was it a reaction by the SPLC to try to stave off an indictment? That's pretty curious. That's pretty curious that the U.S. Attorney's Office was under the impression those things had been destroyed. But then the SPLC is like, no, we got those. Here's 15,000 pages of records in response to a subpoena. And 2 days later, they're indicted. It's interesting. This case is not an outlier in that respect. Nationwide, district courts have increasingly found that this administration has lost the presumption of regularity afforded in court proceedings, et cetera, et cetera. We'll skip all this. And some federal district courts throughout the country have increasingly signaled that the government, under the direction of this Justice Department administration, is no longer operating in a manner entitled to any presumption of regularity. At a minimum, this court should order disclosure of the prosecutor's introductory remarks and legal instructions to the grand jury. I could see that happening. Unlike the substance of grand jury proceedings, the prosecutor's introductory remarks and legal instructions provided to the grand jury are not presumptively covered by Rule 6E's secrecy requirement and does not require a particularized need, according to United States v. Woody's Trucking, and which is a 2018 case in the Ninth Circuit. Commentators have that's not going to apply here, though the judge may be interested in it. Commentators have noted that grand jury secrecy does not govern matters such as court's charge to a grand jury. In fact, what circuit is this? Oops. Let's see. It's under the 11th. Okay. I thought that was right. They cited the 11th earlier. Yeah. That's going to be the 11th Circuit, which I believe Northern. Okay. The 11th Circuit in Thomas. Yeah. The circuit justice is Clarence Thomas. Okay. Yeah. I thought this was going to be the 11th. Okay. Legal instructions, ministerial, conclusion, give it. All right, who signed this? It was Addie Schmidt of the Crop Mosley Schmidt. So that's the three ladies. And then Abby Lowell and people working under him. And then William C. Athanas, Brian Stone of Bradley Arant Bolt Cummings, which is the local attorneys out of Birmingham. And then the other ones, of course, Abby Lowell and the three girls are out of D.C. Okay. Okay, here's a declaration from William C. Athanas, or Athanas, whatever, who is their local attorney for the SPLC. He's over the age. He's an attorney with them, blah, blah, blah. He represents the SPLC. On February 20th, 2026, I contacted Assistant U.S. Attorney John Greer, who advised that I had learned that the Middle District of Alabama U.S. Attorney's Office was investigating the SPLC. I told Assistant U.S. Attorney Greer that I had previously spoken with Assistant U.S. Attorney Russell Dorosky about a prior investigation of the SPLC relating to its use of informants in January 2022, but had not been contacted by the government about that matter since that time. Okay, so I wonder if at that time, Dorosky had asked him about records of the informant program, and if the response had indicated they didn't have any more records, or they didn't maintain records of it, or they had been lost or destroyed or something like that. Assistant U.S. Attorney Greer invited me and co-counsel to attend a meeting at the Middle District of Alabama U.S. Attorney's Office on February 25th, 2026. On that date, I attended a meeting at the U.S. Attorney's Office with co-counsel Addie Schmidt, Sarah Kropf, Andrea Mosley, and Brianna Stone. So even before this indictment, that all-female law firm was working for the SPLC in an effort to understand the nature of the government's current concerns. So the SPLC was proactive in hiring more attorneys out, it seems. At that meeting, attended by acting U.S. Attorney Kevin Davidson and two assistant U.S. attorneys, the prosecutors told defense counsel that they had been advised that the SPLC's internal records of the informant program had been destroyed. I corrected this erroneous belief and agreed to accept service of a grand jury subpoena for records which included, among other things, the information gathered through the informant program, some of which was previously provided to law enforcement. The SPLC produced 14,856 pages of records in response to a subpoena on April 17th, 2026. Nothing in this affidavit is intended to waive attorney-client privilege, etc. So that's all he said there. Okay. I would love to see what all they turned over. All right, next filing, which was on the same day, motion to address government's materially false statements and enforce rules prohibiting further prejudicial extrajudicial statements. This has 2 letters with it. They are from the attorneys. They go back to those records being turned over. This is from April 22nd here, but this one is April 17th, which is when they turned over that information. All right, this is Southern Poverty Law Center's motion to address the government's materially false statements and to enforce rules prohibiting further prejudicial extrajudicial statements. Basically, they want Trump admin people to quit bad mouthing their client. All right, the SPLC respectfully seeks an order directing the government to retract false and unfairly prejudicial statement that Acting Attorney General Todd Blanche made on Fox News regarding allegations against the SPLC, and to refrain from making any further false or otherwise prejudicial statements that compromise SPLC's fair trial rights. On Tuesday, April 21st, U.S. Attorney's Office for the Middle District of Alabama obtained an indictment from the grand jury alleging that the SPLC unlawfully used donor money to fund, quote, racist groups by paying informants who were leaders and organizers of those groups. The indictment, let me get this. There we go. The indictment at 1. A few hours later, before the defense had even seen the indictment, Acting Attorney General Todd Blanche and FBI Director Kash Patel held a press conference in Washington, D.C. to announce and describe the charges, which is normal. That same evening, Acting Attorney General Blanche appeared as a guest on the widely viewed Fox News program, The Ingram Angle. During the program, Acting Attorney General Blanche claimed falsely that the government did not have information to suggest that the SPLC had shared information it learned from informants with law enforcement. Specifically, he stated, quote, and more importantly, there's no allegation or information in the indictment that suggests the SPLC shared the information from the informants with law enforcement. There's no information that we have that suggests that the money they were paying to these informants and these members of these organizations, they then turned around and shared what they learned with law enforcement. To the contrary, or else we would have known from their own words that they had given this money to these guys and we didn't know. Those statements are false. Weeks before the indictment, undersigned counsel provided information to the government demonstrating unequivocally that the SPLC had shared information from its informants with law enforcement. The government's false statements is highly material to the charges. The indictment alleges that the SPLC was paying informants not to dismantle racist groups, but instead paid informants who were engaged in active promotion of racist groups. In fact, the prosecutors in this case knew of specific instances when the SPLC provided information to law enforcement to thwart, stop, or otherwise help dismantle the activities of those racist groups. The defense promptly contacted the acting U.S. attorney, who brought the case to confirm that Acting Attorney General Blanche would publicly retract the statement. Brought the case, confirm. Okay. The government refused to provide that confirmation or take action to correct it. The government's false statement must be corrected publicly. In addition, Acting Attorney General Blanche's false statement gives rise to the concern that the grand jury heard evidence which incorrectly represented the SPLC, that information that was shared with grand jury. It was never shared information received from informants with the government, as well as arguments premised on that erroneous assertion. Okay. I don't think that even if the SPLC does share that information with law enforcement, I don't see how that negates the allegations. Because the allegations are wire fraud and conspiracy to commit money laundering because they lied to these banks and they laundered the money through gift cards and false business accounts. That was the scheme, was how did they pay the informants? And they paid the informants through a scheme that was illegal because it involved lying to federally insured banks. And I don't think it matters. if some of the information they got from these informants was then shared with law enforcement, I don't think that really takes away from the charges here. And it can also be true. It can be true that the SPLC did share some information with law enforcement, but that the government was still unaware that the SPLC was paying these informants through the scheme that it's alleged that they were using. And according to the indictment, they were paying millions of dollars to these various extremists in these groups, including leaders of these groups, and to at least one individual who then dispersed the money to these extremist groups. So that doesn't sound very much like trying to dismantle the groups. They're going to try and argue, I would guess, that we're paying the informants for information on them. And the way we dismantle them is that we then give the information to law enforcement, and it's law enforcement's job to dismantle these groups. But the donors were never aware that this was going on. I get what they're saying, but I don't think it really, I think actually what they're doing is damage control in the media, is they want law enforcement and people in this admin to quit characterizing the SPLC as paying these extremists, and because it's damaging their fundraising. And so really they're trying to do damage control. But this was the immediate excuse that was circulating around when the indictment dropped was, well, what the SPLC was doing is like what the law enforcement does when law enforcement pays informants. And fair enough, but SPLC isn't law enforcement. Law enforcement is aware that they're paying informants. The SPLC's donors are not. Anyway, so this is background. Earlier this year, undersigned counsel were advised by federal prosecutors and the U.S. Attorney's Office in the Middle District of Alabama of the investigation into their client. And we've already read about this meeting. It says that the ongoing investigation, counsel were advised that the investigation covered a range of issues that stemmed from a common root: the SPLC's utilization of a program to pay individuals to infiltrate certain violent hate and extremist groups. I didn't get the impression from the indictment that they were paid to infiltrate these groups. I got the impression they were already part of those groups, as in they were Grand Cyclops and in leadership chats. These people weren't paid to get in the program. They were already in the program. Right. In a second meeting held on April 6, 2026, and attended by acting U.S. Attorney Davidson and Assistant Greer, defense counsel shared information about certain aspects of the informant program in the context of the defense's request for a protective order. This presentation centered on a review of documents relating to the informant program, including specific information gathered from informants and provided to law enforcement to prevent and assist in the investigation and prosecution of criminal activity. That meeting was intended in part to respond to the prosecutor's request for details about the defense's concern that wide-scale dissemination and disclosure of information about the informant program might put numerous individuals, including informants and current and former SPLC employees, and members of law enforcement, in danger from the violent groups they surveilled and others. The parties sought to reach agreement on the production and use of documents relating to the informant program so that the government could conduct its investigation without creating an undue risk of harm to individuals. During the April 6th meeting, all that makes sense. Defense counsel presented documents and information relating to individual A member of Vanguard America, a well-known extremist group, who sought a national security clearance as part of individual A's work at the Philadelphia Navy Yard in 2018. The specific documents counsel provided to the prosecutors showed how and when the informant program gathered and passed information about individual A to law enforcement. In addition, counsel provided copies of federal court pleadings in the Eastern District of Pennsylvania relating to individual A's criminal prosecution based on the conduct of the SPLC that the SPLC reported. Those pleadings revealed that after individual A was indicted, based on information the SPLC provided, the government repeatedly requested that the individual A be detained because of the serious risk of violence he presented. The discussion at the Middle District of Alabama U.S. Attorney's Office on April 6th left no uncertainty. The information developed through the informant program resulted in the detection of individual A's criminal conduct. The SPLC passed information about this to law enforcement. The government investigated and indicted individual A, and individual A was detained and received a prison sentence. Okay. So I was looking to see. So they must, I'm guessing they had an informant. The specific documents counsel provided to the prosecutors showed how and when the informant program gathered and passed information about individual A to law enforcement. Okay. Following that April 6, 2026 meeting, given the message from the Middle District of Alabama U.S. Attorney's Office that it intended to indict the SPLC, defense counsel sent a letter on April 17th to acting attorney Davidson with a copy to Assistant U.S. Attorney Greer. The April 17th letter sought to confirm that prosecutors presenting any indictment to the grand jury would comply with Justice Manual 9-11.233. That section provides that, quote, in United States v. Williams, 1992, the Supreme Court held that federal court's supervisory powers over the grand jury did not include the power to make a rule allowing the dismissal of an otherwise valid indictment where the prosecutor failed to introduce substantial exculpatory evidence to a grand jury. It is the policy of the Department of Justice, however, that when a prosecutor conducting a grand jury inquiry is personally aware of substantial evidence that directly negates the guilt of a subject of the investigation, the prosecutor must present or otherwise disclose such evidence to the grand jury before seeking an indictment against such a person. While a failure to follow the department's policy should not result in dismissal of an indictment, appellate courts may refer to violations of the policy to the Office of Professional Responsibility for review. Okay, so that means that if a prosecutor has information that negates, that explains, that is exculpatory concerning that individual and the evidence given to a grand jury, they don't have to use it to dismiss the indictment if one is returned, but they can be reported to Office of Professional Responsibility for review for misconduct before the grand jury. The April 17th letter detailed 6 categories of substantial evidence that directly negate the guilt of a subject of the investigation, including that the grand jury be informed of the countless examples of the SPLC in fact working to dismantle white supremacist organizations, and specifically highlighting SPLC's involvement in alerting law enforcement to individual A's criminal activity in connection with individual A's effort to obtain a national security clearance. The letter requested that acting U.S. Attorney Davidson confirm by April 20th, 2026, that you have or will inform the grand jury of this and any other information that negates your theories of criminal conduct as it relates to the SPLC. They didn't get a response from the U.S. Attorney. On April 21st, SPLC was indicted, or the indictment was presented to a grand jury. While the indictment included numerous allegations about the informant program, it did not contain any reference to information gathered by the SPLC through the program and provided to law enforcement. It doesn't have to, though. At 5:30 p.m. on April 21st, DOJ held a press conference to announce the SPLC indictment. Blanche and Patel each offered prepared remarks and answered media inquiries regarding the indictment and responded to media inquiries on certain other topics. Shortly after the press conference in that evening, Blanche went on the Ingram angle on Fox News. During his interview, Blanche made a number of statements about the indictment of the SPLC. Ingram asked him, quote, now they SPLC, meaning them, now they say they're no longer using these informants in this way and that it was necessary because they had all sorts of threats against the organization, firebombing threats and other acts of purported violence, and that's why they had to use these informants. And to that you say, Blanche responds, well, to that I say, for one, the indictment charges that all the way through 2023, So I'm here to speak about what they're doing, not here to speak about what they're doing right now, but that indictment charges a long period of time through 2023. It's 2014 to 2023. And second, and more importantly, there's no allegation or information in the indictment that suggests they shared that information with law enforcement. Well, they say they did. Well, they communicated when they chose to with law enforcement over the years. There's no information that we have that suggests that the money they were paying to these informants and these members of these organizations, they then turned around and shared what they learned with law enforcement. Okay. I was expecting it to get to that point. SPLC is going to be able to say we shared information from our informants to law enforcement. And the question is, yeah, but was it information from these specific informants on which the behavior that's mentioned in the indictment, the charges are based on? Did you pay F-37 hundreds of thousands of dollars to organize the as part of his leadership in the organizing the Unite the Right rally? And did you supervise his racist postings online and pay him money in an effort to get information about it? And then did you turn that information over to law enforcement? Was that what you were paying him for? Like, can you show that? I don't think they can, because they were laundering their payments to these guys. If what they were doing was above board, why did they go through all the things they did to disguise their payments to these informants? Information counsel provided to the Middle District of Alabama U.S. Attorney's Office on April 6th, a mere 2 weeks before the indictment, demonstrated that Blanche's bold statement of the above was false. The prosecution, in fact, had information that established that the informant program produced information shared by the SPLC with law enforcement. And they're mentioning this individual A again, but the indictment of the SPLC doesn't connect to individual A, unless I'm missing something. They haven't drawn that. The defense promptly notified the prosecution that Acting Attorney General Blanche had made a false statement. I don't think it's false. I see how they're able to characterize it as false, but I don't think it's false. As detailed above, the individual informants. Let me try that again. As detailed above, the government was aware that on numerous occasions the SPLC received information from individual program informants and shared what they learned with law enforcement. Then they again mention individual A, which isn't the conduct around individual A is not related to the conduct that is charged here. In 2019, the SPLC gathered through the informant program and provided to law enforcement information that detailed the risk that individual B, a member of a white supremacist group, Adam Waffen Division, intended to engage in a major terrorist attack in Las Vegas. The press release issued later by the DOJ detailed individual B's planned violence. Individual B admitted that during online conversations between May 2019 and July 15, 2019, he discussed setting fire to Las Vegas synagogue and making Molotov cocktails and improvised explosive devices. Individual B further admitted that he conducted surveillance on a bar that he believed catered to LGBTQ community located on Fremont Street in downtown Las Vegas in preparation for a potential attack. The complaint filed by the government against individual B, signed under oath by an FBI special agent, detailed specifically just how close individual B got to executing a mass terror attack. Okay. But individual B was charged, pled guilty, and was imprisoned, but the conduct there doesn't connect to the indictment. Prior to his filing this motion, the defense asked the government to correct its false statement to avoid the need for court intervention. In response, Acting U.S. Attorney Davidson did not address the assertion that the SPLC provided information obtained by its informants about individual B to law enforcement. So they have those two individuals and successful prosecutions, but they don't connect to this indictment. Okay. DOJ is well aware SPLC provided helpful information through its use of confidential informants to law enforcement. DOJ also knows that these confidential informants help law enforcement put violent extremists in jail. But did DOJ know you guys were laundering money and committing wire fraud and paying these informants? I don't think you told them that part. Okay. Okay, the rest of it talks about that the attorneys need to be barred or reminded that they're not supposed to make prejudicial statements because the false misleading statements at issue here are sufficiently egregious to merit court information according to them because they could prejudice potential jurors and they would misunderstand what the SPLC was doing. They're trying to, there's a fallacy here. The part mistaking that what's true for the part is also true of the whole. It's that fallacy here. They're trying to say that what's true for part over here is true for the whole. So here we did a good thing with individual A and individual B. That's what we did for everything involved in the informant program. And the indictment is specifically saying, no, you didn't. And they're accusing Cash, Patel, and Blanche of also making a similar mistake because they're in Trump, because they're saying they're characterizing what we did in part as being true of the whole, when they say that they were paying extremists to be extreme and to engage in extreme behavior. Okay. Notice they're not, speaking of each instance, notice that in this, they're not defending, I'm sure they will at some point, but they're not defending the individuals in the indictment that are mentioned, the F's that are mentioned, the informants in the indictment, and that specific behavior in the indictment that the charges are based on. They're not addressing that. They're raising these other issues that make a better sounding story. Let's see what they say about Charlottesville. In each instance, the speaker has not confined their comments to the content of the indictment, but has instead advanced talking points, such as accusing the SPLC of funding hate groups like the KKK, sowing division in the U.S. through support of such groups, and organizing the rally in Charlottesville that led to the death of Heather Heyer. Acting Attorney General Blanche has made false factual assertions to further the narratives. Ms. Levitt claimed that the indictment shows that Charlottesville was a hoax perpetrated to discredit President Trump. Mr. Patel said that the SPLC engaged in the ultimate hypocrisy by funding hate groups they claim to want to take out, and Mr. Singh claimed the SPLC was deceiving the American people, all to promote fake racism. President Trump, during a 60 Minutes interview, stated that Charlottesville was all funded by the SPLC as part of the rigging of the election. President Trump further stated that the allegations in the indictment are not just allegations, these are facts. They link to those statements. Whether by design or independently, these communications are being published and amplified on platforms that are widely consumed by the jury pool that will be called upon to adjudicate the actual allegations against the SPLC that are contained in the indictment. As a result, even before the first court appearance in this case, the SPLC finds itself the subject of relentless criticism and threats triggered by these comments. I partially agree with them. I do, because I think they have an argument here. I don't think it actually rises to the level of the court needing to do something about it, but it's the same thing we saw. I had a problem with Biden and Garland and Jack Smith and some of the statements they made, and I just think prosecutors and Justice Department officials should let the filings do the speaking. They can reiterate what's in the filings, but I think there's just too much media interaction. All right, they go on. That's that filing. These letters that accompany it as attachments really just restate what was already in there, so we don't really need to go through those. Let's see if the government has responded. Nope, not yet. We will save that for the next update in this case. We'll see what DOJ has to say in response. It could be quite spicy. All right, let's catch up with what's happening in the United States v. Cole Tomas Allen, the would be assassin, the educator from California who traveled to the White House Correspondents Association dinner last weekend and attempted to barge through a United States Secret Service security detail and magnetometer setup, blasting one of the agents with his shotgun, drawing fire from another agent, and then apparently tripping or being tackled just a few feet past that. He never made it anywhere close to the president or members of the president's cabinet. They were another several dozen, at least, Secret Service agents were in between where he was and the ballroom where the dinner was happening. And it was on a whole nother floor below the floor that he was on. He was on the terrace level, and that's one floor up. He would have had to make it through all those agents, down the stairs, past more agents, and then he would have entered the ballroom at the back, and he would have had to have made it through all the people, all the journalists there to get to where the president was. However, it was a very dangerous situation. He was armed with a shotgun, he was armed with a pistol, and multiple knives. And I already went through in a previous video, which there's a playlist for this case on my YouTube and on my Rumble. If you go to the playlist tab, you'll find it right there, United States v. Cole Allen. He already went through the indictment against him, well, the complaint against him and the affidavit. He hasn't been indicted yet. They haven't taken all of this material in front of a grand jury yet. They probably will, and they're probably going to return an indictment that has more charges than what he has right now. But right now, he's charged with attempting to assassinate the president or members of the cabinet and discharge of a firearm and commission of a violent felony. There was some drama this week in this case, and it has to do with the judge. First, there was a little bit of drama at the detention hearing. Initially, he was held on a 3-day detention. That's completely normal, a 3-day hold based on the oral motion that the government put forth right after his arrest. And then they had a detention hearing. And I'm going to take you through some of the highlights from the detention hearing documents because the government put out this 20-page memorandum arguing for pretrial detention. And in it, they included a lot of evidence that wasn't available in the affidavit that we went through in the previous video, including pictures of the weapons that he had, pictures of the hotel room. They had a whole exhibits list. They had pictures of the area where he fell. Right here, you can see there are the stairs. There's the shotgun. Which, when you look at it this way, it's almost like he fell. Did he fall going down these stairs? These aren't the stairs that go all the way down to the ballroom, by the way. There's another set that he has to get to. It's a long way down. They have more pictures of the ammo that he had, the weapons, and then pictures of Cole Tomas Allen. Pictures of him while he's in his hotel room, some of the other items he had in his hotel room, a still shot of him running through the magnetometer with the shotgun in his hand. Other items that he had in his hotel room, including more ammo, gas mask, goggles. I guess he was expecting, I might get pepper ball or something. That looks like the kind of equipment you would use for that. Some duct tape. But at the detention hearing, the government, they geared up to present all of this stuff at the detention hearing. And they ended up not having to, because at that hearing, as it was beginning, Cole Allen's own defense counsel said, never mind, we're going to waive argument for detention, and we're not going to argue for it. Keep him detained. And I don't know what their reasoning for that was. I haven't found a news article that actually spelled that out, why, or I don't know if the defense attorneys even said why, but they declined to argue for his release. They did file a motion against, it's 11 pages, in support of his pretrial release. And it's pretty academic. It just restates the basics of what the government must prove at a detention hearing and why Congress passed these laws and what Supreme Court recognizes. And it's just pretty academic, plain stuff and not really specific to his case until you get to a few things where it says, look, the government's case is speculative. They don't even they haven't filed in their motion what the type of ammo he was or what type of ammo he actually did have, whether it was buckshot or slugs, as if that really makes a difference. Their theory is that he intended to commit a mass shooting, but their evidence for that is that one email, and that email doesn't actually say that, whereas it says a lot of things that don't help their client. And really, it's a good try. their motion for pretrial release, it's like, good try, not gonna work, but good on you. You had to file something. Um, so anyway, they waived that, and he ended up being detained. And then that's when some drama happened. He was put on suicide watch. And that doesn't seem to have been a decision that DOJ made. That seems to have been a decision that Department of Corrections made. And you probably heard that the judge at a hearing this week was not happy about that and that he apologized to Thomas. So I want to get into that today and pick apart what went down at that hearing, because there's a bit of fake news floating around as to what happened at that hearing, and there's some rage bait going on, and I always like to neutralize that kind of stuff. So, all right, first let's get to this memorandum in support of his pretrial detention, because in here there's some new information. All right, so the charge is, I left one out earlier. They are attempt to assassinate the president, transportation of a firearm and ammunition with the intent to commit a felony, and then discharge of a firearm during a crime of violence. More charges are probably going to come from this. I'm not sure what all they'll be, but I think he's going to get charged with more than that. But they're probably going to take this in front of a grand jury and get a proper indictment. All right. Scanning this for new information. The description of this here leaves out whether someone was shot. It says the defendant sprinted through one of the magnetometers at the checkpoint, ran in the direction of the stairs leading to the ballroom where the president and members of his family and cabinet were located. As the defendant did so, he held a shotgun in both hands in a raised position parallel to the ground. A United States Secret Service officer observed the defendant fire the shotgun in the direction of the stairs leading down to the ballroom. The officer and others at the checkpoint heard the gunshot. The officer drew his service weapon and fired 5 times at the defendant. The defendant fell to the ground, was restrained by law enforcement, and was placed under arrest. The defendant suffered a minor injury to his knee but was not shot. Doesn't say anything about whether or not Cole actually hit someone, but we know an agent was shot in the vest and was treated for that. So I don't know why. I don't know if they left that out because they're still trying to determine for sure whether or not Cole hit him or if it was friendly fire. There was some confusion about that, and I believe I heard either Cash or Janine Pirro say, no, Cole shot one of our officers. But one of the thoughts I have is that perhaps they're trying to determine for sure, 100%, that Cole did hit one of the officers, or was attempting to hit one of the officers, because they're going to charge him with that. They could charge him with attempted murder. So I saw a theory going around that maybe since he was using buckshot, that maybe one pellet caught an agent in the vest, but the rest did not impact him. They're probably trying to count and recover all of those pieces of buckshot. I'm sure they already have by now. So before they state anything as on the court's record as to what Cole shot and where those projectiles went, they probably want to be absolutely certain about what they're putting in here. That might be why they left that specific information out. Or we might find out that they were mistaken and that it was friendly fire. Who knows? At the time of his arrest, the defendant was in possession of a Mossberg 12-gauge shotgun, and the action of it had 1 spent cartridge in the barrel and 8 unfired. So he was not able to eject the round that he fired, but this does go to show he did in fact fire. I've seen speculation that he didn't fire. You can tell. Like I've seen some people point at the video and say you don't see the shotgun blast in the video. Well, it happens like that. So maybe in the frame rate it was skipped. I don't know, but he definitely fired, because you can hear it in the audio from the various cell phone video that's around, and in the television network audio you hear it fire, and then you hear the response from the one agent firing back, and then there's the spent shell casing, and then of course there's wherever those projectiles went. Additional 6 unfired cartridges were attached with Velcro to the shotgun in a detachable ammunition carrier, and the defendant possessed another 10 unfired cartridges in a small leather bag. I don't believe we knew that. I don't believe that was in the affidavit we read in the other video. He also had 2 additional handgun magazines and a 1911 38 caliber pistol. He did legally purchase both of those weapons, the shotgun on August 17th, 2025, and the pistol on October 6th, 2023. He possessed 2 knives, 4 daggers, sheaths and holsters for them, needle nose pliers, wire cutters, and his cell phone. And this goes into the search of his hotel room. Law enforcement recovered, among other evidence, 2 additional knives, magazine, 10 rounds of ammunition, 2 boxes, each containing 10 rounds of shotgun ammo, a half face piece respirator, roll of duct tape, 2 rolls of grip tape. Law enforcement conducted a search of his parents' residence outside of LA, where the defendant resided. So this is a leftist educator. He's a college grad, teaches at an engineering school. He lives with his parents in LA. In his bedroom, he had 2 long gun bags, a Mossberg shotgun stock, pistol holster, training pistol. Then here are photographs of those items. So he replaced this stock with a foldable one at some point. Here are the knives, needle nose pliers, small ones, and snippers. Not sure what he planned to do with those. At some point before the attack, the defendant wrote emails explaining his actions. We went through those in the previous video. The defendant's apology and explanation letter also included a list of hypotheticals or hypothetical objections to the defendant's plan to kill the president and other senior U.S. government officials, with the defendant's responses to the hypothetical objections. One of the defendant's hypothetical objections was, "You didn't get them all." In response, the defendant wrote, "Got to start somewhere." Another of his hypothetical objections was, "Yield unto Caesar what is Caesar's." In response, the defendant wrote, "The United States of America is ruled by the law, not by any one or several people. Insofar as representatives and judges do not follow the law, no one is required to yield them anything so unlawfully ordered." In a postscript in his letter, apparently written from inside the Washington Hilton after his arrival and observations of security measures related to the upcoming dinner, the defendant ranted and described what he viewed as deficiencies in the security at the hotel. He wrote that he walked in with multiple weapons and not a single person there at the hotel considers the possibility that I could be a threat. The defendant went on to complain that if I was an Iranian agent instead of an American citizen, I could have brought a damn Ma Deuce in here, which is 50 caliber machine gun, M2, and no one would have noticed shit. The defendant signed his letter, Cole Cold Force Friendly Federal Assassin Allen. That is going to be cited often in this case. Friendly Federal Assassin Allen. And at the end of the letter described how he felt awful about what he was about to do, but he experienced rage thinking about everything this administration has done. His final words were, "Can't really recommend it, stay in school, kids." Although just days old, the investigation of the defendant's assassination attempt has yielded significant evidence of the defendant's extensive planning and preparation for his attack on April 25th, 2026. Here's where we get some new info. On March 2nd, 2026, President Trump publicly announced that he would attend the dinner, posted it on his True Social account. Trump added that it would be his honor to accept the invitation to the dinner, and the March 2nd post was publicized by various media outlets. A little over a month later, on April 6th, at approximately 2 p.m., the defendant used his cell phone to search, quote, "White House Correspondents' Dinner 2026. So this tells you they have access to his phone and are going through his search history, text messages, emails, browsing history. Less than 2 hours later, at 3:28 p.m., the defendant received a confirmation email for a 2-night stay at the Hilton from April 24th, 26. So April 6th, 2 p.m., Cole looked the dinner up, and then less than 2 hours later, got confirmation that he had booked a hotel for that weekend, the same hotel. 10 days later, on April 16th, the defendant used his cell phone to access a series of online media articles discussing the dinner, including its host, the event schedule, and expected attendees. At some point before April 21st, 2026, the defendant purchased a one-way Amtrak train ticket from Los Angeles, California to Washington, D.C. via Chicago, Illinois. On April 21st, the defendant used a rideshare application to travel from LA Union Station, where he boarded a long-distance Amtrak passenger train to Chicago, a route famous for its scenic views of the mountains and deserts of the American West before traversing vast expanse of the Great Plains. While en route on April 22nd, the defendant used his cell phone to view a news article titled Trump's Plans for Mic Drop Media Confrontation Are Leaked. The president is planning a rage-fueled moment at the White House Correspondents Association dinner. The defendant arrived in Chicago in the afternoon on April 23rd. A few hours later, the defendant boarded a second Amtrak train to Washington, D.C., this time passing through the Great Lakes and Appalachia regions of the United States. While en route from Chicago to D.C., the defendant again used his cell phone to visit the website of a D.C. newspaper to view an article titled Social Scene, Your Guide to the 2026 White House Correspondents' Dinner Weekend. So this type of information just goes to show why he was going there. It was his intention all along to carry out this attack. He brought the weapons with him. He brought the ammo with him. On the way there, he booked his hotel for the weekend of the dinner. On the way there, he's looking up information about the dinner, about the event. The defendant also kept a running note on his phone of his observations and thoughts during his cross-country train journey. He wrote that, quote, the Southwest desert in spring, distant wind turbines looming like snowy mountains across the hazy New Mexico desert. That Chicago is cool, kind of like an Iowa small town with scaled up to LA size, and that Pennsylvania's woods are awesome. The defendant arrived in D.C. at approximately 1:10 p.m. on Friday, April 24th. Approximately 30 minutes later, the defendant purchased a Metro Smart Card with a 3-day bus rail pass. He then traveled by Metro train from Union Station to DuPont Circle and checked into the Washington Hilton at 3:15 p.m. The next day, April 25th, was the night of the dinner. On that day, the defendant left his room at the Washington Hilton multiple times. During one occasion on April 25th at approximately 6:26 p.m., the defendant left his hotel room for approximately 20 minutes. During that time, he used his cell phone to visit the webpage Presidential Schedule Civic Tracker. He's trying to figure out where Trump is. At approximately 8:03 p.m., while back inside his hotel room, the defendant used his cell phone to take a photograph of himself in the mirror. In the photograph, which is the one on the below left, the defendant was wearing a black dress shirt, black slacks, and what appears to be a red necktie, tucked into his pants. An enhanced version of the image below right shows that the defendant also appeared to be wearing a small leather bag consistent in appearance with the ammunition pouch, later recovered on his person, a shoulder holster, a sheathed knife consistent in appearance with one of the knives later recovered from his person, and pliers and wire cutters consistent in appearance with those later recovered from his person. About 10 minutes later, at approximately 8:13 p.m., the defendant again visited the Presidential Schedule Civic Tracker webpage. Approximately 2 minutes later, he exited his hotel room. At 8:27 p.m., just minutes before the attack, the defendant used his cell phone to visit a media company's website and access the video Watch Live President Trump First Lady en route to White House Correspondents' Dinner. He also visited another website to view live coverage of the president exiting his vehicle to attend the dinner. Less than 1 minute later, the defendant searched, quote, Trump White House Correspondents' Dinner on a web search engine. The defendant's pre-scheduled emails with the apology and explanation attachment were sent a few minutes later at approximately 8:30 p.m. Shortly thereafter, the defendant rushed the screening checkpoint on the terrace level of the Washington Hilton with a raised shotgun. So this just shows mens rea, and it shows all of the pre-planning he was doing and how it all ties into Trump's arrival at the dinner and him targeting Trump. And I wonder if he thought he could time his breaching of that checkpoint if he could catch Trump before Trump was seated, or if he thought Trump was going to be walking in, he could catch him like en route traveling through the hotel or traveling into the ballroom. But of course, Trump was already seated and was up on the stage at a table with Melania and other members of the cabinet. I'm not sure if he planned for Trump to be there, because the way he would have entered, he would have been at the back of the room. So let me go back to this image I used the other day. So he's up here at this level, And there are the stairs that go down to the ballroom here. Trump is over here on this stage, at the back of the room. Trump is down here. He would have entered through one of these stairs if he had made it. And these are like there's not one stair, it's like multi-level stairs. As you could kind of see that in the images, that the stairs continued. You see right here, there's one set. These are just like, there's like 5 or 6 steps there, and then there's another several steps there. So I wonder if he thought he could catch Trump coming in, like walking through the crowd or something, because where he's entering here, he's got all of the tables and dinner guests set up there. It's just a long way. I'm just curious. He might have thought he could catch him en route, because he seems to have timed it for right when Trump was due to arrive, right? Okay. The rest of this is arguing for him to still be detained. And of course he is. All right, let's get to the some kind of controversy that happened at the most recent hearing. First, I'll show you the documents for it. Right here, so his detention is here, and case called for detention hearing but not held. The defendant waives the detention hearing, and finding facts concerning detention reserves the right to present any future request for release. There's the transcript of it, which isn't available yet. And then this is going to be the next day or 2 days. I think it works out to be 2 days later. The hearing was on the 30th. So on May 2nd, there's an emergency motion to remove suicide status by Allen's attorneys. And next day, there's a notice of a hearing, emergency motion set for 5/4 at 12 p.m. in person in front of Magistrate Judge Zia M. Faruqui or Faruqui. I'm not sure where he wants the emphasis on the syllable, but that's the magistrate judge, one of the magistrate judges in D.C. who handles this case. His name has come up quite a bit in cases I've covered. It happened in D.C. anyway. And he says right here, a representative from the Department of Corrections shall be present at the hearing. So the judge's issue is not with DOJ. The judge's issue is with Department of Corrections. Why is this man on suicide watch? May 3rd, so that same day, later that day, motion to vacate motion, to withdraw, vacate hearing, and emergency motion to remove suicide status. Notice of hearing by his attorneys. And his attorneys say, Cole Tomas Allen, through undersigned counsel, withdraws his motion for removal from suicide status at the D.C. jail. Since filing the motion, undersigned counsel have learned that Mr. Allen is no longer on suicide status. As such, Mr. Allen's request is moot. Counsel therefore respectfully requests the court cancel the upcoming hearing, and it's all good now. By the way, he has 3 public defenders. AJ Kramer, Tazira Abe, and Eugene Ohm are his public defenders. Same day, the judge says, minute order. Defendant's motion to vacate is denied. The court has grave concerns about defendant's seemingly unprompted solitary confinement for days and overall conditions of confinement. As such, the parties and a representative from the Department of Corrections shall appear in the courtroom at noon on May 4th to explain the conditions of his confinement. So that happens. And it says motion hearing is held, emergency motion removed from suicide status. Defendant was present in the courtroom. He remains held without bond. The Department of Corrections stated its housing board was still considering where to place the defendant. As such, it is hereby ordered that the D.C. Department of Corrections shall submit an update to the court by 9 a.m. May 5th, detailing when it will make final housing determination. It is further ordered that the D.C. Department of Corrections shall inform the court where the defendant will reside at the jail as soon as it makes that determination. I'm going to refresh, see if there's any update on it, because today's May 5th. So far, no update on it. That's what happened. He was placed by the Department of Corrections on suicide watch for a couple days. Emergency motion was filed by his attorneys to remove that status. They filed for a hearing for it. The judge was like, "Yeah, we're gonna have a hearing about this. Department of Corrections explain it," and then they immediately said withdrew it, and said, "Never mind, he's been taken off. It's all good now." And the judge is like, "No, I still want to hear about it. I still want to know why this defendant was on suicide watch and what his conditions are." At the hearing, when it happened, this is why it made news, because the judge apologized to the defendant. From Newsweek, Cole Allen gets apology from judge after alleged Trump assassination plot. A federal judge has apologized to Cole Tomas Allen, the suspect in the alleged assassination attempt of President Donald Trump at the White House Correspondents Association dinner in April. Magistrate Judge Zia M. Faruqui made the remarks in court on Monday after he had on Sunday raised grave concerns, quote unquote, about Allen's treatment in custody. The judge had ordered a representative of the Department of Corrections at the hearing. In a brief order Sunday, Faruqui said he was concerned about Allen's seemingly unprompted solitary confinement for days and overall condition of confinement. On Monday, he told the alleged wannabe assassin, quote, "Whatever you've been through, I apologize for that now." Newsweek has contacted the attorneys for comment. And then it restates all the same things I told you, but it doesn't give us much more information. Let's see what Fox News. Let's go with the local one. No, that's not the one I want. Let's go to this one. Politico, judge says alleged White House correspondent attacker being mistreated by DC jail. Magistrate Faruqui said Cole's placement in severe lockdown, including a temporary suicide watch that required 24-hour-a-day placement in a padded, lighted cell without access to phone calls, books, religious material, or recreational time, appeared to be unfairly punitive and not based on any known medical assessment. Faruqui, who played a role in hundreds of cases stemming from January 6th on 2021 attack on the Capitol, and I'm going to talk about that in a minute, said Allen was being treated more harshly than those defendants, despite similar allegations of political violence aimed at members of Congress and government leaders. Those defendants were housed in a less restrictive wing of the jail known as Central Treatment Facility, he noted, and were given significant accommodations during their detention. So Politico actually has a report of what was said in the hearing. Quote, "The Jan 6 defendants were all moved to the CTF," Faruqui said. "Pardons may erase convictions, but they do not erase history. He's being treated differently than anyone I've ever observed." Faruqui emphasized that despite grave charges against Allen, the court and jail are still supposed to presume his innocence, particularly because he has no criminal history. He apologized to Allen, saying it was partly the court's role to ensure that someone detained while awaiting trial was subjected to fair and dignified conditions. Faruqui ordered DC jail officials to update him by Tuesday morning on when and whether Allen would be moved in less restrictive conditions. Though it houses federal inmates, the DC jail is run by local officials who make determinations about the housing status of criminal defendants detained pretrial and those serving sentences. Tony Towns, the general counsel for the DC Department of Corrections, said decisions about Allen's housing were made with an eye toward his safety, not to be punitive. And I've come across that before in cases where they move a defendant to a suicide watch or solitary confinement area or something like that, not because of concerns that that defendant is suicidal or because they've acted out in a way where they're like, they're not safe to be around other people. So they put them in solitary. They put them there to keep them away from other people in the jail. So it's for that defendant's own safety. And I've seen that come up in a bunch of cases where that happens, not just in DC, but in lots of different jails. And the defendant's attorneys always complain about it and use it to draw sympathy for their client, to say they're being mistreated. We haven't been able to talk to them about their case. They're being deprived their phone calls. They're being isolated. It's bad for their mental health, all of these things. And then when you call the Department of Corrections people up, they're like, yeah, well, there were some threats to this defendant, and it was safer for us to put them in this area for a short period of time while we found a different area and while we dealt with the people who we believed were a threat to them. So, and when you understand that, it makes perfect sense. And the jail is actually doing the right thing. I'm not saying that's what happened here. It is the explanation. They're saying that they did this with an eye toward his safety and it was not punitive. And we haven't heard anything about him being suicidal, though in his apology email he sent out, he acknowledged that he probably wasn't going to make it, or he was at least going to be in need of a visit to a hospital really bad after what he did. That's how he phrased it, in the sense that I probably need to go to the hospital really bad if you're reading this. By the time you read this, I need to go to the hospital, because he was expecting to be shot while he was attempting to assassinate Trump, right? And what he was doing was a suicide attack, in a sense. So, in a real sense. So, this has drawn a bunch of complaints. Faruqui, this magistrate judge, apologizing to the person who last weekend tried to assassinate Trump. And that's the rage bait I was talking about. You see all sorts of rage bait from tons of accounts saying this judge signed arrest warrants for hundreds of J6ers and he slandered them. He's an activist judge. He needs to be removed from the bench. He's a radical leftist. He's a radical Muslim, because he is like a Pakistan immigrant. Of course, Julie Kelly, you can always count on her for rage bait. That's basically all she ever does. This judge has signed arrest warrants for hundreds of J6ers. He used some of the harshest terms to describe J6ers, including those accused of no violence, but now he's apologizing to this psycho who tried to kill multiple people, including the president. When will the judge apologize to J6 defendants? You saw that a whole lot. People saying this judge never apologized to J6 defendants. Right here, he never apologized to J6 defendants, but now he's apologizing to this Trump assassin. And there's tons of it. There's so many posts like this, right? Well, and there's this one from Joel Berry, who I like a lot. He says, this judge, the judge who just apologized to Trump's attempted assassin Cole Allen for the way police restrained him, the last year, this same judge dismissed the case against Edward Alexander Dana, who threatened to kill President Trump. We have a big problem. And he's a Trump-hating Pakistani Muslim, by the way. And in the whole comment section is just people raging about activist judges and leftists and the treatment of J6ers, et cetera, et cetera. Okay, I'm going to talk about Edward Alexander Dana, in just a moment. But first, I want to go ahead and neutralize the falsehood that Faruqui didn't apologize to J6 defendants. He, in fact, did. He, in fact, apologized to a number of them for the way they were treated, including back on March 7th, 2022, he apologized to Lucas Denny, a J6 defendant who was delayed being brought to court for a detention hearing. He said to him, this is from the transcript, I cannot begin to express how deeply frustrated and apologetic I am on my end, because you have been lost for more than 1 minute or 1 hour or 1 day, but for nearly a month or longer, really, when you calculate it. And there's Mr. Denny, there's just no excuse to treat a human being like that. I don't need to tell you that, but it needs to be stated out loud. That is not how I would want to be treated if I were in your shoes. And it bears repeating that you are presumed innocent. I don't care how you're dressed, where you came from. When I look at you, I see a presumed innocent person. That is what he said to Lucas Denny, a January 6th defendant, on March 7th, 2022. And there's more. There's more times that he apologized for them. And the reason that Politico, in their article about this, they point back to January 6th immediately in their article. And as slanted as they can be, they did a really good job here, because Faruqi's comparison, they went back and cited how Faruqi handled January 6th defendants. Faruqi's comparison to January 6th defendants dredges up a fraught aspect of the 4-year prosecution of people charged and convicted of breaching the Capitol. The nationwide manhunt began in the height of COVID era and severe housing restrictions for all inmates in the DC jail. January 6 defendants routinely lamented their conditions in the jail, noting that they were subjected to similarly severe lockdowns. limits on their access to lawyers, challenges in reviewing evidence of their criminal cases, and concerns about access to medical care. Their complaints, bolstered by a large network of supporters, ushered in substantial changes to jail operations. Inmates were given freer access to evidence and jail issued tablets, and some were accommodated for gluten free or vegan dietary needs. One January 6 defendant's complaints about unmet medical needs prompted a judge to investigate and ultimately hold the jail in contempt of court, forcing changes. And substandard conditions forced some inmates to temporarily be relocated to facilities in neighboring states. Faruqui, however, said Allen appeared to be facing restrictions that no January 6 defendant did. Quote, he can be both kept safe and treated with dignity. Right now, it's not working. I think it's legally deficient. And ultimately, if the DOC, Department of Corrections, can't do it, I'll speak to the U.S. Attorney's Office. I know they have other facilities they can contract with. If you all cannot handle it, we're going to have to reassess that with the marshals and the Department of Justice. If we can get some vegan food, we can get you a Bible, the magistrate judge added. Prosecutors said little during the hearing except to note that Allen had informed FBI agents the night of alleged assassination attempt that he hadn't expected to survive, a detail that the jail might have relied upon in considering him a suicide risk. But Faruqui underscored that the medical professionals disagreed and said he interpreted Allen's purported remark to be an indication he expected to get shot, not that he was seeking to end his life. So, another instance where when you go to the documents and when you go to what actually took place in the courtroom and you understand what everybody said, and when you look at the actual history, not the reactionary takes from the Twitterati, I don't have that. We used to call the outrage of the left on X the Twitterati. I don't have a good name for the X people who do it on the right, but when you learn a little bit of history and you go back and examine some things in the context and you look at the judge's past comments and how they treated like for like, you learn that actually this guy isn't that, or at least in this instance, maybe he doesn't deserve all the criticism and rage that he's gotten over the past several days. And what he said to this January 6th defendant is consistent with what he said to this defendant, Cole Tomas Allen. It almost makes you think he's a good judge, huh? It almost makes you think, dang, that judge is a good one. Of course, we're not supposed to think that because he signed arrest warrants and search warrants for January 6 defendants. And, aren't you, we're supposed to be partisan hacks, that's how you get clicks and likes. So let's talk real quick about this guy, Dana, because I really like Joel Berry, but I think he might be mistaken about this. He said right here, just last year, the same judge dismissed the case against Edward Alexander Dana, who threatened to kill President Trump. We have a big problem. And I believe Mr. Berry is mistaken. A grand jury refused to indict Alexander Dana. A federal grand jury declined to indict a defendant accused of threatening to kill President Donald Trump. U.S. Attorney Janine Pirro's office, this is from September 2nd, 2025, informed a magistrate judge Tuesday afternoon that a grand jury had refused charges against Edward Alexander Dana. That judge was Magistrate Judge G. Michael Harvey. He denied a request from prosecutors not to disclose that information to Dana's attorney. Dana, who described himself to police as a person with disabilities, was charged last month with threatening to kill Trump while he was being arrested on suspicion of damaging an exterior light at a restaurant in Northwest DC. So we have a person who was in some way committing vandalism at a restaurant in DC. And while he was being arrested, he commented that he wanted to kill Trump. And then he was charged with threatening to kill Trump. According to charging documents, Dana told police he was intoxicated at the time and claimed to be a descendant of the Huguenots, a group of French Protestants who mounted a series of rebellious actions against the crown in the 17th century. Dana's case marks at least the 7th time since Trump's federal surge began in D.C. that a grand jury has declined to support charges fielded by Pirro's office. I think that was supposed to say filed. It's also the second time prosecutors have failed to secure charges against the defendant accused of threatening Trump. Earlier Tuesday, a grand jury had refused to indict another defendant, Natalie Rose Jones of New York, for allegedly making threats against President Trump. Last month, prosecutors were rejected 3 times in their efforts to indict a woman, Sydney Reed, for allegedly assaulting an FBI agent during an ICE arrest. And then you might remember Sean Dunn throwing a sandwich at Border Patrol officers, and a grand jury declining charges for assault by Subway sandwich, assault by hoagie. So I don't think that this comment by Joel Berry quite jives with what took place. A grand jury declined to bring charges, and this is the local news reporting that. Fox News reported the same, and so did The Hill. DC grand jury passes on indicting a second person, and it was Edward Dana. But Edward Dana did have another charge. He had another case, right? Because there was vandalism. So when you go and look at his case, and I found it right here, threats against the president, there's the complaint. Here it is. Here's the affidavit in support of it, followed by an officer. And Dana also said this is Donald Trump's way of saying, hey, I can look like Putin. The Constitution is being attacked. And saying that he was going to go back there and destroy more. I'm going to go back there to the restaurant and fuck that person up. I'm going to beat the shit out of them, and I'm going to make sure they remember. Blah, blah, blah. He later claimed to be affiliated with the Russian mafia and then threatened the officer. I don't tolerate fascism. And that means killing you, officer, killing the president, killing anyone who stands in the way of our Constitution. I'm going to kill you. All right. So arrest warrant was issued. This is all back in August of 2025. And then this is in front of Magistrate Judge Moxilla A. Upadhyaya. More filings, and at some point there's going to be an indictment that failed. Around this time, September 2nd, and this is when his attorneys were informed that the grand jury passed an indictment. Defense requested dismissal of the case on that same day. Dismiss case. Memorandum in support of motion to dismiss. Count for lack of probable cause right there. Order as to Edward Alexander, September 4th, from Magistrate Judge Faruqui. And what does it say? September 4th, the parties appeared before the court for a preliminary hearing. The government emailed the court saying that a short time ago they filed misdemeanor charges in D.C. Superior Court against Mr. Dana. So that's not federal. It's the same. This is D.C., remember? And as we know from other cases, in D.C., the U.S. Attorney's Office is responsible for prosecuting defendants in both the local court, which is the D.C. Superior Court, and in the federal D.C. District. So this right here was initially federal charges for threatening the president. After the failure to indict, they filed misdemeanor charges in local court, probably for vandalism or threatening an officer or something. I don't know what it was exactly. Doesn't really matter. Based on this, the government stated it no longer intends to pursue federal charges on this issue. The government concluded it anticipates filing a motion to dismiss the federal case before the close of business today. The government sought to cancel this hearing before the undersigned based on this. However, doing so would have precluded any oversight of the government's inexcusable actions. At the hearing, the court ordered the United States Attorney's Office to file a memorandum addressing the following issues. 1, when did the government inform the defense it was seeking to dismiss the case? Why was the motion to dismiss not filed at the same time the misdemeanor charges were filed in Superior Court? Why was a motion to dismiss not filed before the preliminary hearing? Why was a motion to dismiss not filed the moment the government decided to dismiss the case? What is being done to remedy what happened to Mr. Dana, including a motion to dismiss with prejudice and or expungement of his arrest record? Totally reasonable. Totally reasonable. The government doesn't get to charge you in one court and then file charges in a different court around over the same incident and dismiss you over here, but you're being held here and you're in this limbo phase. And then it doesn't have to, it has to, and then this is not how you handle it. It's not fair to the defendant. If the government is not seeking to dismiss the case with prejudice and expunge Mr. Dana's arrest, it is then ordered to submit a briefing as to why not. So this is the order from Faruqui saying, no, you have to explain yourself. You can't just say, oh, never mind. You have to explain why this man was in jail and why he was charged with this, and then why you are now dismissing this case. Makes sense to me. So, same day, motion to clarify was filed by the U.S. Attorney's Office explaining what went on. And then September 5th, motion to clarify. The order was signed by Judge Faruqui, and then they gave a response on it, and then reply in support of motion to dismiss and to dismiss the case with prejudice and to expunge the arrest. So to me, it looks like Judge Faruqui is just making sure that things are done correctly. Maybe I'm off base. You can let me know in the comments if you think I'm off. And I've never before have I looked at something from this judge and thought, oh, wow, this judge is really good. I've never thought that. But in these little incidents, in this one with Dana, and in this incident with Allen, and then in this incident with Denny, the J6 defendant, it looks to me like a judge trying to do the right thing. And that's his job. And that's also why it sucks to be a judge, because no matter what you do, one side of the courtroom is always mad at you. No matter what you do, one side always thinks you're crooked, no good, very bad person and should be removed from the bench. No matter what you do. Sometimes both sides think that, right? And that's how it goes. And no matter what you do in this day and age, people complain about it on X for money. Because if you can produce some rage bait on X about something going on with a judge and a hot topic in the media, you're going to make money from clicks and views. Okay, so that's your update. Allen is held without bond. He's not on suicide watch. And mostly what we're waiting for is an indictment in this case, a motion to dismiss, of course, from Allen's attorneys. That's the status of the case right now. So, all right, that's your update on United States v. Allen. Thanks for watching. Let me know what you think about it in the comments. Okay, in the case of Heather Natanson at the Washington Post and what's his name? Is it Martin? No, Aurelio Perez-Lugones. All right, so Perez-Lugones was the defense contractor who stole classified reports about Venezuela last fall and over the winter and gave those to Washington Post reporter Hannah Natanson right here. And you may remember her property was raided and her devices were seized. And then this guy was arrested. And when he was arrested, he had classified documents on him. He had them in his vehicle, in his lunchbox, in his basement. And this guy is detained. Hannah Natanson is not charged with anything, but she's filed this lawsuit to get her property back. And the Washington Post has joined her in it because some of the property belongs to the Washington Post, like her laptop. And in this has just been a back and forth over the search warrant and what the government has access to. And then there's attorney-client privilege stuff. There's all sorts of privileged material on her devices. So there's been a back and forth with the court over what the DOJ has access to, and it's gone before a filter team. And the prosecutors and the investigators in this case, in this case, are not allowed to access things in these devices yet. Or at least last I checked, they were. We're gonna review what the current status is. But this one is this is a civil matter here where they're going back and forth over the property that was seized from Hannah Natanson. This is the criminal matter of Perez-Lugones. And just yesterday, a trial was scheduled. So the trial is set for, it doesn't say right there. When is the trial? Okay. With the coffee money you guys send me, I have purchased this document so that we can find out when this trial is. It is pretrial motions due there, responses due here. A pretrial motions hearing is scheduled for October 1st. By October 16th, defendant shall file this. Any motions or requests for hearing on these matters shall be filed by December 4th. Motions in limine are due by December 4th, 2026. Responses December 8th. We're getting there. We're getting there. Copy of each party's labeled ones, and a pretrial conference Friday, January 15th, 2027. So that would be a year from when he was arrested. A 10-day trial by jury shall commence on February 22nd, 2027. I doubt that holds. I bet that either there's going to be a plea agreement here or it's going to get pushed back. But as of now, February of 2027 is February 22nd is when this guy is scheduled to go to trial. I'm going to download this document so I can keep referencing it in the future. I'm going to highlight a name so I can save it. A good title. Trial scheduling order. Go. Save. Oh, I didn't save his name. I want you to save the name of the case. I don't know why I'm still recording this. Copy. Okay. Trial scheduling order. Okay. I have a feeling I'm going to look at that in the future. Okay. There we go. Thank you for the coffee money. That allowed me to get access to that document. And that's really the only thing that's gone on here in this case since we last referenced it. There's been some back and forth having to do with SIPA, which is the Classified Information Procedure Act, but there's the indictment on January 22nd, but since then there hasn't been, big motions from the defense to dismiss or to either all of it or dismiss one count or anything like that. That's where we're we got this. That's the big news here on this one. All right, let's take a look at Hannah Natanson and her devices. All right, the most significant thing here recently, April 9th, the judge made an order that modified the standstill order. And that standstill order came down back in January. January 21st, which told the government, you can't look at the devices yet. You got to process them. You got to pause searching them for information that would inform this case or any other case that might derive from those devices. And they have a processing team that came in. They're the CART team is what it is. And they came in and they processed those devices. And the judge modified the order on April 9th to say, okay, the government is permitted to finish processing the seized material, but the government may not substantively review any data from the seized material. Only CART members who have no connection to the underlying investigation may process the seized material, and the government must ensure that those members are walled off from the prosecution and investigation teams with no communication between them regarding the search warrant or the underlying investigation. That's order number one. Order number two, the government must submit a report on the status of its efforts by 5 p.m. on April 17th. Number three, the government status report must also provide the court with a point of contact to initiate court review as well as a list of proposed non-confidential search terms, et cetera, et cetera. Number 4, by April 24th, move-ins may file a brief describing their position on the government's proposed non-confidential search terms. Order number 5, this has to do with privileged communications there, because Hannah Natanson, as a reporter, had hundreds, if not 1,000, contacts with various people who work in government and are in either are sources for her, or there's also attorneys she talks to. So some of the material on these devices is privileged, has nothing to do with the investigation. So this is all about filtering that out. All right. So they went back and forth on status report. Let's see what the most recent thing is. There was a status report here. Motion to seal weekly status report. Yep. Was sealed. Response by Washington Post on the sealing of the status report. There's the sealed status report right there. April 24th. Then motion to seal the next. So every week they're updating the judge, and that status report is sealed. And then we have this order. And it's a significant one. All right. Order that the objections of the government be and the same hereby are overruled, and the decision of Judge Porter proceed as set forth in the memorandum opinion is affirmed by Judge Tringa. Okay, let's see what this is. Before the court are the government's objections to the magistrate judge's opinion and order on the motion for return of property, document number 74. Did I miss that? When was document 74, return of property? Motion objections to magistrate judge's opinion and order. Motion to return property. What came after that was this filtering thing where they gave a report each. Where did that go? See, here's the April 9th order. Okay. Return it. I guess it's return it after they finished processing it. All right, the court held a hearing on objections on April 9th, following which the objections under advisement for the reasons stated here, the objections are overruled. Magistrate judge's decision to review the seized documents is affirmed. Okay, it's not the magistrate. Okay. They're affirming the review. Okay. Okay. All right, October 31st, 2025, Natanson co-authored an article that was published in WaPo that the government contends contained top secret, secure compartmented information, no foreign classified information from the government intelligence report. After the federal government, after the FBI investigated the unauthorized disclosure of the classified material, Aurelio Perez-Lugones, a government contractor with a top secret security clearance, became a suspect. The FBI uncovered 5 instances of Perez-Lugones accessing classified information, and that it then appeared in the WaPo article. So 5. I remember in the previous video I tied each one of those to each article. On January 8th, 2026, the government arrested Perez-Lugones on criminal complaint issued out of the District of Maryland, charging him with unlawfully retaining national defense information in violation of 18 U.S.C. 793E. On January 12th, as part of the government's investigation of Perez-Lugones, an assistant United States attorney for the EDVA applied on an expedited basis for a search warrant to seize materials from Natanson, who lives in the Eastern District of Virginia. Initially, the magistrate judge who received the search warrant application rejected the government's proposed search warrant due to, quote, concerns about both the scope of the proposed search warrant and the government's apparent attempt to collect information about Ms. Natanson's confidential sources. On January 13th, the assistant United States attorney submitted another search warrant, which the magistrate judge also rejected, following which the court held multiple in-person and telephone conferences with the U.S. attorney, who presented successive versions of the proposed warrant. until the court ultimately approved that search warrant. Quote, limited to all records and information, including classified or national defense information, from the period of October 1st, 2025 to the present, which constitute records received from or relating to Aurelio Luis Perez-Lugones as evidence of violations of 18 U.S.C. 7093. The court's probable cause finding rested principally on three allegations. One, on multiple occasions, Perez-Lugones had provided Natanson with top secret and other classified information that appeared in her published articles days later. Two, they had exchanged this classified information using Signal. And three, they had set their messages to auto-delete after 1 day. On the morning of January 14th, 2026, the FBI executed the search warrant on Natanson's home and seized 2 laptops. Ooh, so they waited to make they waited to arrest him until they could get a search warrant for Natanson. But the court was like, no, this search warrant's way too broad. It needs to be more specific. I remember he had taken documents that day that he was arrested on January 14th, if I remember the indictment correctly. So they actually ended up catching him in further criminal activity. That day, I think I remember speculating that they might have waited for a day where they could catch it in his hand. I wonder if they would have waited anyway, or if they would have moved ahead if they had gotten that first search warrant. That same day, counsel for the Washington Post contacted the government requesting that the government refrain from reviewing any of the material on the grounds that the seized material contained materials protected by the First Amendment and the attorney-client privilege. After multiple rounds of meet and confers, the government agreed to withhold an initial substantive review of the seized material on January 20th, or until January 20th, but ultimately rejected WaPo's proposal to return those seized materials. January 21st, Natanson and WaPo filed in this court to intervene for the return of property, requesting all the seized material be returned. The government opposed the motion, arguing that privilege review conducted by the government filter team, which is that CART team, would adequately protect the privilege information. Movements also moved the court for a standstill order to preserve the status quo, which was granted. February 24th, Magistrate Judge Porter issued an order denying Movement's request. And I remember when that standstill order was granted, people were like, oh, this is so crooked, judge, DC judge, protecting WaPo, protecting classified leakers. People got to be outraged about something. All right, February 24th, Magistrate Judge Porter issued an order denying Movement's request for the return of all seized property, but granting their alternative request for return of non-responsive materials, which makes sense, and in the first instance, conducting an independent judicial review of the seized material. As a threshold matter, Judge Porter emphasized that the government's failure to reference and analyze in its warrant application the applicability of the Privacy Protection Act seriously undermined the court's confidence in the government's disclosures in this proceeding, adding that if the government had disclosed the PPA's applicability, the court may have denied the warrant application entirely. Judge Porter also found that Movement's First Amendment rights had been restrained through the government's seizure of all of her work product, documentary material, and devices. Recognizing that Movements do not enjoy absolute press immunity from legal constraints, Judge Porter reasoned that Movement's First Amendment rights must be balanced against the government's compelling interest in its prosecution and protecting classified national security information. Makes perfect sense. And therefore, the court could not simply order the government to return all devices and permit Movements to unilaterally identify material responsive to the search warrant. In balancing these issues, Judge Porter relied on the Fourth Circuit's decision in search warrant application June 13th, 2019, also called the Baltimore Law Firm case, to conclude that the court should conduct the responsiveness review of the seized material, which under the government's own admission likely only contained a small fraction of material responsive to the government's interest. And given the large swath of information unrelated to the government's investigation that contains privileged information protected by the First Amendment, attorney-client privilege, Judge Porter concluded that the unique facts and circumstances of this case precluded the government's filter team from reviewing the fruits of this search warrant. All right, government made objections to this. And in its objections, the government argues that the magistrate judge erred when he ordered a judicial review of the seized material. In assessing whether the magistrate judge correctly concluded that judicial review of the seized material is appropriate, the court has considered applicable constitutional rights and protections under the First and Fourth Amendments and the PPA, as well as the executive's Article 2 authority and duty to prosecute wrongdoing and protect classified and sensitive information. The government does not dispute that the seized material likely contains information about Natanson's confidential sources, information about her colleagues' sources, conversations with sources, notes, recordings, draft articles, and similar materials. The movements claim those materials enjoy protections under the First Amendment based on the reporter's privilege, the doctrine against prior restraint, as well as the PPA. The government argues that the documents do not enjoy protections under either the First Amendment, reporter's privilege, or the doctrine against prior restraint, and that any protections afforded under the PPA do not require judicial review. The government's expansive view of what is permissible under the Fourth Amendment entirely disregards Natanson's rights under the PPA and First Amendment, which entitle news reporters to some constitutional protection of the confidentiality of their sources. This is true. This is true. And they cite several cases here. Although a reporter's privilege is not absolute and will be overcome whenever society's need for confidential information is in question outweighs the intrusion of the reporter's First Amendment interest, the Fourth Circuit has instructed district courts to conduct the following three-part balancing test in weighing these interests and determining whether the reporter's privilege can be overcome under the Fourth and First Amendments. 1, whether the information is relevant. 2, whether the information can be obtained by alternative means. And 3, whether there is a compelling interest in the information. The government argues that the search warrant clearly authorized a search for documents and information relevant to its law enforcement duties, namely classified and or national defense information or materials during a specified time period relating to Perez-Lugones. And therefore, the warrant implied authorized officers to open each file on the computer and view its contents, at least cursorily, to determine whether the file fell within the scope of the warrant authorization, even if that information exists among a large swath of information that is unresponsive to the search warrant. But here, the only documents relevant to the government's efforts in investigating Perez-Lugones' alleged criminal conduct may be as few as a handful of documents, while the non-responsive, irrelevant news-gathering materials constitute over 1,000 documents, and there is no compelling interest in the government reviewing these irrelevant documents if there is an alternative means to identifying the relevant documents, namely judicial review. Although it is conceivable that the government, under certain circumstances and conditions, may be authorized to conduct a search of seized materials that includes First Amendment or PPA-protected documents, the government has not cited and the court has not identified any case with a seizure comparable in scope and content to the one in this case. Makes a lot of sense to me. The government contends that the seizure does not constitute a prior restraint or speech because Natanson is not prohibited from engaging in any expressive activities in the future. The government's seizure of the entirety of Natanson's work product, including her active stories, her notes on future investigations, and her background and confidential source material, fundamentally affect Natanson's ability to publish in the areas she was investigating. That makes sense to me. Okay. Let's see. The privacy issue is, really, that's obvious. And judicial review seems appropriate to me. Okay, so what is the end result of this? Conclusion. For the above reasons, the court concludes upon a de novo review that judicial review of the seized material is warranted, and also that the magistrate judge's decision to do so was not clearly erroneous or contrary to law. hereby ordered that the objections of the government in the same hereby are overruled, and a decision of Judge Porter to proceed as set forth in his memorandum is affirmed. Okay. That makes sense to me. So this review is still happening. And at the end of it, whatever materials are related to this guy will be turned over to the investigators, and the rest and the devices themselves will go back to Natanson and WaPo. And that is the status of these two related cases. All right, there's your update on that. I don't know if Natanson's going to be charged, but I think there's a good chance she'll be charged because it appears she might have been she was directing him on what to look up, and reporters can't do that. I hope DOJ brings those types of charges. That's where journalists cross the line. A journalist can receive stolen, classified national defense information, but they can't seek it out. That's the problem. All right, guys, that'll do it for this episode. Thank you for listening. Thank you for watching, and thank you for supporting. I had to purchase a couple documents in this episode, and I was able to do so thanks to you guys making purchases at my link tree, all the support options, and with your subscriptions to justhuman.substack.com. Really appreciate it. Be blessed, be human, and I will see you on the next one.